Good morning, ladies and gentlemen. My name is Hans Limapo. I work with Limapo Law Firm, and I am invited to do the presentation today on joint ventures. The presentation is called Introductory Thoughts on Joint Ventures, as you can see on slide 1. The presentation is developed against the background of the Suriname Oil and Gas Summit networks tailored to investment and business development in Suriname, and to assist the participants in growing their business in Suriname. This presentation is prepared under the assumption that Suriname law applies. I will first give a short introduction and then elaborate on 2 overriding principles to which parties considering to enter into joint venture negotiations should abide by. The presentation will then briefly point to the 2 common forms of joint ventures under Suriname law. Then I point to some characteristics of the Memorandum of Understanding as a prelude to the joint venture agreement. I will follow up by briefly pointing to 3 typical clauses relevant to include in the joint venture agreement. I conclude with some final thoughts. Introduction. The joint venture is arguably considered the most satisfactory means of achieving objectives which are beyond the capabilities of either prospective joint venture party on its own. It is a suitable medium for one party to solicit the capital investment of another with similar needs or interests in order to reduce the risks and costs of adventure or to create an enterprise large enough to overcome the entry barriers of a given field. The new enterprise is not intended to become the dominant activity of either or both of the parties. If such were the case, the better route would be to unite on a permanent basis by way of an acquisition or merger. The proposed enterprise is intended only to create narrow community of interests between the 2 parties, and thus establishing a link by means of a joint venture is often the preferred route. The dilemma of autonomy versus control. In most joint venture arrangements, the parties face a fundamental dilemma. On the one hand, they want the joint venture to have the authority to run its business itself. And on the other hand, they want to know that the necessary safeguards are in place to ensure that their interests will be protected. Key question is thus how to give the management of the joint venture appropriate decision-making powers while at the same time protecting the interests of the joint venture parties. There are 2 relevant overriding principles to which parties should subscribe when considering entering into a joint venture, as we see on slide 2. The first principle is that unlike mergers and acquisitions which require complete accord at only a single point in time, a joint venture necessitates continuing agreement between the parties as to the nature and scope of the enterprise. Thus the potential parties must focus on the venture and attempt through extensive negotiations to define its scope, the standards they will adopt, the market that they plan to enter, and the size and possible lines of growth of the venture. Each party must understand the motivations and interests of the other, what it intends to gain by the venture, what changes it might wish to make, and what alterations it is likely to propose. By a long and deliberate process of discussion and negotiation, the parties should explore every conceivable area of potential conflict until they come to a realistic understanding of the nature and limits of their community of interests. The second principle is that of compatibility of the parties. Fundamental conflicts may arise, say, between one party with a risk-taking philosophy and one committed to a conservative pattern of corporate growth, or may result from the joining of two parties of disparate size or with significantly different cash positions. The choice of party is thus the first and most important business decision to be made when considering establishing a joint venture. Unless there is trust between the parties, and unless there is a substantial unity of interest, the joint venture approach will indeed be a risky one. Where these criteria are met, the problem of serious disagreement will often be more theoretical than real, in particular with regard to parties of stature in their particular industry. Such parties are likely to be managed by individuals with similar experience, attitudes, and values, leaders in the business community who can be expected to act reasonably in an effort to avoid critical disagreements. Depending on their interest and desired involvement in the conduct of the joint venture's affairs, compatibility with non-industry partners may be less critical. International investors, for instance, are mainly interested in guaranteed return and an exit option. Now we head to slide number 3, structuring issues. The joint venture structure constitutes a limited association between two or more parties to further a single commercial endeavor, in which each owes fiduciary duties to the other. When the venture involves a long-range, large-scale operation, the intended parties may desire the advantage of an incorporated or unincorporated joint venture. Under Suriname law, these would normally take the form of respectively an NV, which is a separate legal entity limited by shares, or a CV, which is a limited partnership. In line with the limited time scheduled for this presentation and the purpose of this online session, it might suffice to only briefly point to two characteristics of these two forms. The first question is consolidation of the business of the joint venture into the financials of the joint venture partner possible? For the NV, the answer is yes. If the JV and the respective joint venture party form an economic unity of legal entities and partnerships that are organizationally interconnected. Under Suriname law, this is generally assumed to be the case, where an entity can exercise the majority of the voting rights or appoint or remove a majority of the directors, for example by virtue of its shareholding or a JV contract, or where it can otherwise exercise management control over such entity. As for the unincorporated GV, the limited partnership, consolidation of the business of the JV into the financials of the joint venture party is possible if this concerns the sole management partner. The limited partnership is a partnership with typically one managing partner and one or more silent partners. The managing partner is in control and in charge of the management and operations of the JV business, endowed with the power to represent and bind the partnership. Whereas the silent partners are investors with certain rights, such as, for instance, access to information, approval of budgets, and determination of strategy of the JV business. Thus, an unincorporated JV limited partnership is not a separate legal entity. The business of the JV is naturally part of the financials of the managing partner. Then the second question concerns limited liability and risk management. As for the incorporated JV, yes. The answer would be yes. The risk of director and shareholders' liability is in practice rather remote with regard to the incorporated JV. As said earlier, the JV in the form of an NV is established under Suriname law as a separate legal entity limited by shares. Consequently, only the NV itself will be liable for its debts. The shareholder will be liable only for its paid share capital, and the board of directors will only be externally liable for debts of the NV in the exceptional circumstances of fraud, that is, willingly contracting debts while cognizant that the NV would not be able to satisfy such debts, or actively contributing to the non-fulfillment of the debts of the NV and frustrating recovery therefrom. As for the unincorporated limited partnership, the answer as to the limited liability and risk mitigation would be no. The managing partner is liable for all debts of the partnership. As mentioned earlier, the JV in the form of a limited partnership is not a separate legal person. The managing partner performs the JV in the name of the partnership, that is, for the risk and account of the partnership. However, the managing partner is externally liable for the debts of the partnership, and its creditors have recourse against all assets owned or held by the managing partner, either pro se or in the name of the limited partnership. Slide number 4. How do we get there? How do we get to entering into a joint venture arrangement? The response should be through an MOU. At the outset of negotiations, joint venture parties will generally have to address 3 questions: the objectives of the negotiations, the rules of the game relating to the negotiations, and the consequences if the negotiations break down. The first concern relates to the content of the deal and its delimitation, whereas the second and third concern relate to the process of the deal and, in essence, its protection. As a means of allaying these concerns, potential joint venture parties will often look to sign a document shortly after the commencement of the negotiations, such as an MOU, which records their intentions with regard to the three concerns mentioned above. This document could also be a heads of agreement, heads of terms, terms of reference, or a letter of intent. More often than not, when preparing such a document, the potential joint venture parties tend to focus on the wrong issues. If one were to ask the parties why they enter into such documents, the majority might say it is to set out the principal terms of the deal formally in writing. This approach is arguably misplaced. The potential joint venture parties should in fact rather be focusing on the second and third concerns, namely the process of the deal. All too often, parties will spend time debating whether or not to make a MOU legally binding. As far as the parties' objectives are concerned, namely the principal terms of the joint venture, they will in most instances not be legally binding as they lack certainty. The very reason why parties will enter into negotiations rather than conclude an agreement immediately. However, the MOU will arguably be binding in as much as it relates to the process of the deal. In essence, the parties will be obliged to behave in a particular way in relation to the negotiations, that is to say, in good faith. The concept of good faith involves obligations such as to disclose material information, to abstain from misrepresentations, to abstain from making patently unacceptable propositions, to abstain from breaking off negotiations without good reason, to abstain from negotiating with third parties at a time when the other party would reasonably understand the negotiations to be exclusive. An MOU can thus act as a useful framework for the negotiations, giving parties focus as to their objectives, but can generally only bind morally in relation to their content, as opposed to the process of negotiations. As for the rules of the game, the typical rules of the game relate to confidentiality and exclusivity. Those are assumed to be already familiar to you, so I will not further elaborate on these. Restrictions in the event of termination. The potential joint venture parties should also consider what mechanisms should be put in place in the MOU to protect themselves should negotiations come to an end before the joint venture agreement is entered into. Deal protection arrangements include, for instance, restraint of trade and standstill provisions. This brings us to slide number 5. 3 typical issues that need attention from the joint venture parties, especially when the form of an NV is considered as an incorporated JV. Minority protection. A minority shareholder in a joint venture is commonly advised to look for express contractual protections of its interests in the joint venture. This is because under Suriname law, shareholders in an NV do not owe fiduciary duties to each other. In the absence of express additional contractual rights, a minority shareholder's rights will depend on the extent of its shareholding. While from a point of view of legal analysis, the incorporated joint venture does not constitute a partnership, from the point of view of the practicalities of the parties' needs, the relationship is very much one of partnership type, analogous to what the law prescribes for a partnership. Certain fundamental decisions are contemplated to be taken by the parties unanimously because the decisions relate to the essential partnership structure and because of the risks which are generated by it. Preemption rights. Parties entering into a joint venture do not normally expect the right to dispose freely of their shareholding or interests, nor do they consider the other party free to dispose of its holding or interests, because this could well result in totally incompatible parties being thrown together. It is thus usual for joint ventures to adopt a legal form where the transfer of shares can be forbidden forthright, indefinitely, or restricted in a manner provided in the joint venture company's articles. Deadlock procedures. The fundamental equality of structure or the creation of basic rights requiring unanimity or qualified majorities in joint venture arrangements can lead to deadlock situations if the parties cannot achieve agreement, and thus risking the development of the enterprise of the joint venture. It is often difficult to devise a deadlock breaking procedure consistent with the needs and business understanding of the joint venture parties concerned. Usual procedures in joint venture arrangements might involve one or more of the following: referring to an independent third party, appointing a swingman, arbitration, buy-sell options, and Russian roulette provisions. Referring to an independent third party, appointing a swingman, and arbitration procedures provide for a decision by a third party, and the two other procedures are a form of discontinuation of the venture. Parties may have serious doubts about the competence of any outsider to render an acceptable decision on matters of business policy. Discontinuation, on the other hand, can lead to significant destruction of value. Hence, in many instances, the reluctance of parties to accept beforehand the risk of having a provision imposed on them in circumstances that they cannot anticipate. They may prefer to accept, without qualification, the principle of joint action and joint agreement on all questions, relying entirely on the compatibility of the parties and their attitude of good faith and cooperation to reach voluntary solutions under all circumstances. They may also prefer to trust the common sense of parties to agree an appropriate deadlock resolution mechanism if a dispute has arisen nonetheless. As a conclusion, slide number 6, we may say that the joint venture is a comprehensive arrangement which parties conclude to embark on a continuing adventure. This presentation has assumed Suriname law to govern the relationship between the parties. Where negotiations take place cross-border or the joint venture parties are from different jurisdictions, choice of law has to be considered. I wish you all success in this online event and in the near future. Thank you.